everybody. I am Emilio de Capitani, former official in the European Parliament, currently retired but working also on fundamental rights and data protection. But to start with our panel, let me first introduce our panelists. Mrs. Birgit Sippel on my left is since many years a member of the European Parliament and of the Civil Liberties Committee, who is in charge of most of the freedom, security and justice area policies, giving a body, a content to judicial and police cooperation in criminal matters. This committee is also responsible for the protection of EU funding values, fundamental rights, anti-discrimination, transparency, protection of personal data, and human mobility inside and outside the EU. Mrs. Sippel is then both the memory and also a very active actor in this very influential committee. Catherine Forget is the lawyer of the Ligue des droits de l'homme, which years ago brought an important judicial case challenging the EU directive on the passenger name record. The Court of Justice followed the request and considered that respect for fundamental rights requires that the powers provided by the PNR directive should be strictly limited to what is strictly necessary. Merve Hickok is president of the Center for Artificial Intelligence and Digital Policy. I always say data protection because DP is a Pavlovian reaction. So, okay, digital policy in Washington, and is also representing here Mark Rothenberg, who has been along more than 20 years an interlocutor of the European Parliament Civil Liberties Committee delegations when discussing the transatlantic dimension of security and data protection. Anze Erbeznik is an European Parliament official for several years in the LIBE committee, assisting the members on several proposals dealing notably also with judicial cooperation in criminal matters. Myself, I had the privilege of serving the Civil Liberties Committee for a rather long period before the entry into force of the Amsterdam Treaty, which established the objective of developing the European Union as a freedom, security and justice area. And this, I had this committee until the entry into force of the Lisbon Treaty, and 2 years later in 2011. During that time, I'd witnessed the tireless action of the committee in the fundamental rights domain, and notably in a data protection saga since the adoption of the Regulation 45 in 2001. May I remind you that data protection has been the most relevant domain of action of LIBE since the Echelon case in 2000, the safe harbor, the passenger name record, the TFTP agreement with the United States, and other interesting and important initiatives. In all these cases, the European Parliament was trying to balance the need for protection of the individual with the need to grant a high level of security, as it is required by the treaty. Last but not least, may I introduce you this rather unknown free group, which in fact is a bunch of scholars and activists that I had the chance to meet along my work for LIBE. But between these people, there are names very well known, like Stefano Rodotà and Spiros Simitis, who very unfortunately passed away, but who have marked the history of European data protection. Why have we chosen the title of our panel? Because the tension between the protection of personal data and the demand of increased public security, be it real or only virtual, is increasing, no matter of the provision of the treaty and the EU Charter. But again, as my old friend Stefano Rodotà was saying, protecting personal data is protecting people. But now I have to give the floor to Birgit Sippel, and I have prepared some questions. The first one, if we agree, is how does you see the role and the success of the European Parliament in the field of data protection, privacy, artificial intelligence, fundamental rights in the digital sphere, meaning more or less 2 words on the universe?
Okay, that's an easy question. Where shall I start? First of all, maybe a fundamental remark that, of course, with all the developments regarding digitization, artificial intelligence, more and more things are happening in a digital world or are done with digital means. So, of course, we have to adapt our rules to this new and ever faster developing reality. On the other hand, I very often hear, what is illegal in the analog world should also be illegal in the digital world. In principle, we could agree to that. But I have more and more the impression that some actors have the idea that collecting all the data in the internet, all the digital data, all the data, will help us to ensure 100% security. I may later give an example for that. And that simply is not true. Talking about fundamental rights, it may also be true that fundamental rights never exist to 100%. Sometimes even two fundamental rights might clash into each other. But never can we allow to totally ignore fundamental rights. And that's what I'm afraid sometime is happening. So what I see is that for the time being, with all the digital files we are working on, the European Parliament, at least yet still, a majority in the European Parliament, is the only actor between all the institutions, Commission, Council, Parliament, the only one fighting hard to protect fundamental rights. We are very often complaining about member states not enforcing legislation, but what we see more and more is that even the Commission is not playing its role as guardian of the treaty, is not ensuring that fundamental rights are used, are implemented. Even worse, the Commission, when posing new proposals, for example, regarding new rules on Schengen, is not forcing member states to respect the rule, to respect fundamental rights, but is simply legalizing the wrong behavior of member states in the past. So what does it mean for the future and for predictive policing? I think we have to be very careful because so far many actors are concentrating on individual files, like, for example, on PNR. And there might be some good arguments to say we need to collect some kind of data and maybe some rights need to be restricted. But then we have a lot of files, and if with every file we do restrict a right, how much in the end will remain from those rights? We also, and I maybe in this short introduction, I will only say, no, I will mention one example, one current example, or two. We are just talking about the European health data space. And there is good reason to have a European health data space, but there is also good reason to protect individual health data. They are very sensitive. Not everybody should simply have access to it. But the way the Commission has done the proposal is giving the idea that's a simple idea. And we even hear lies about it. If only we have all the data, we can do all the research on all illnesses that we have. Sorry, that's not true. Because you do not only need data, you clearly do not need all the data from everybody. You do need money, you need many other things to do researches. And another bad example, very emotional example, is the CSAM, the child sexual abuse material, where even the legal service of the Council is saying this is not acceptable. You are totally ignoring fundamental rights, and it will not help. And the promise that we can protect all the children and keep all the children, get them out of their unacceptable situation is a total lie. It will not happen. I'm just coming back from a visit to Washington, where we also talked to the FBI. And some of my colleagues were really shocked because the United States, they collect many data, including those of child sexual abuse. And they have the almighty FBI. And when asking if the FBI, having all the material, will now, of course, investigate in all those cases, the answer was, what? No, we can't. Because it's too many cases, we have to focus on the most serious ones. Nevertheless, we continue to pretend that if only we collect more data, it will help. And we are not only collecting tailored data for people, areas where we believe there is a reason to look into. The proposal of the Commission, including a detection order in the end, means that in the end, all kind of communication from everybody at all time will be looked into. And that's going much too far and only shows that the Commission itself is not respecting fundamental rights. And that's something I'm really concerned about. And I only hope that at least with the statement of the legal service of the Council, we will have different debates in the Council. And I also hope that beyond the draft report from the rapporteur, we will also ensure big improvements in the report from the Parliament side. To be honest, me personally, I even would like to have a chance to take away this proposal and do a new start for a better, more tailored proposal. So to make a long story short, yes, we have to work on digital areas, but at the same time, we have to protect fundamental rights, instead, step by step, lowering the level of fundamental rights. And if we lower data protection, it's not only protecting data, it's protecting privacy, it's protecting confidentiality of communication, it's protecting health data, it's protecting freedom of expression. So it's really the basis of European Union, which is founded on common values and fundamental rights. And therefore, we have all good reason to be very critical and ensure that we do not forget our basic principles and values.
Thank you, Birgit. A very interesting and emotional intervention. I have to share your opinion and to support that the idea that finding a needle in a haystack is not to increase in the haystack, maybe, and we should be more focused and maybe rely on some apparently traditional and old approach, which are more protecting for the fundamental rights of the people. Now, may I give the floor to you, Merve Hickok, who is, as I told you, the director of the Center on Artificial Intelligence and Digital. Well, go on.
Thank you so much. And maybe I'll start. A lot of my focus is going to be AI and fundamental rights. And as the CPDP, although we are based in DC, we have been mainly working globally, a lot of our work in EU, until US AI policy picked up significant pace in the last few months. So we've been heavily involved with EU AI Act, Council of Europe, OECD, etc. And something that in terms of fundamental rights, putting the fundamental rights and democratic values in the middle, in the center of the conversation, something that was surprising was when coming back to the EU AI Act, when it was first proposed, there were a lot of fundamentally, by their nature, in conflict use cases by their nature that was in conflict with fundamental rights, such as predictive policing, biometric categorization, emotion analysis, etc., and lack of redress mechanisms for that matter. So a lot of our conversation since April 2021 was, one, banning these applications that significant or are, like I said, starting with in conflict with fundamental rights, but also are concerned that by including them as high-risk use cases or subjecting them to transparency requirements, etc., instead of banning them, that EU would be legalizing and de facto normalizing some of these pseudoscientific applications, and that it could set a precedent for other jurisdictions. Having said that, I think we also need to acknowledge in US, in EU, and in other countries that we always look at corporate world and challenge them, say that they wouldn't change their business model unless there was regulation, and even then they would change it as much as required for compliance. But I think we also need to call out on the governments, because governments are not looking to change their business model either. Again, coming back to the EU AI Act, there were significant ex-ante exclusions on law enforcement use case of AI, as well as migration and border management, again, significantly undermining the fundamental rights and significantly undermining the objective of the EU AI Act. I would be more than happy to go into the rights and values-based versus risk-based. Obviously, we're not happy with the risk-based approach to start with. But if we're not able to start over again, and it is risk-based, there are significant concerns on how government is using AI in these spaces and how fundamentally undermining fundamental rights and democratic values and rule of law, because a lot of these law enforcement and migration use cases also are in conflict with presumption of innocence. You already assume that a refugee or asylum seeker is possibly a criminal, is risky. You already assume a lot of low-income communities and low-income neighborhoods in your country is risky. So we need to start, I think, with those assumptions, as well as focus on government use as much as we focus on commercial uses, and have guardrails in place for both of those. Happy to go into more detail later, but I'll start with that introductory remarks.
Thank you, Merve. May I just ask you, I think that CPDP already sent several suggestions at European Union level and also at the Council of Europe level, where a convention on artificial intelligence is currently negotiated. Can you tell us more on it?
Thank you for that question. Yes, we have been involved with both EU AI Act and the Council of Europe for multiple years now. And some of the concerns we have on like I mentioned, a part of our concerns for the EU AI Act as it relates to rule of law and fundamental rights. But those are similar at the Council of Europe level as well. Council of Europe is supposed to be, by its mandate, creating this international treaty, legally binding international treaty based on human rights, democracy, and rule of law. So as opposed to European AI Act with its dual objective of market harmonization and protection of rights and safety, Council of Europe actually has a mandate that is supposed to protect fundamental rights. And what we're saying right now and are very concerned is it is becoming instead of a complementary instrument, it is becoming a copy-paste of risk-based approach. And that is very concerning, because what Council of Europe treaties do is they actually can be ratified and adopted by more countries. So whereas European AI Act is applicable in the EU space, any country around the world can adopt Council of Europe. So it can be an international legally binding treaty, just as 108 Plus or Budapest Convention. The way that it is going right now as a risk-based convention and significantly some attempts to water down the fundamental rights protection, if it goes through the way that it goes through, I think that international treaty will be, like I said, a copy-paste of EU AI Act without the necessary, or even less, because it's going to lack some of the other mechanisms that makes European legislation effective to a certain extent. So significant concerns with the Council of Europe side, as well as EU AI Act.
Moreover, if I am not wrong, there is also the treatment of the current text negotiated in the Council of Europe, which is rather blurred, is not transparent, and there was even some problems with the leaked text of the draft convention. So it's a pity that an issue so important and so close to the interest and rights of the people remain negotiated under more or less closed doors. But again, good luck for continuing in insisting not only at the European Union level, but also at the Council of Europe. We just spoke of a possible transatlantic dimension of these issues, and so I propose to give the floor to Catherine Forget, who is, as I told you before, the lawyer for the Ligue des droits humains, who raised a very interesting case before the Court of Justice, challenging, through the intervention of the Belgian Constitutional Court, the legitimacy, the necessity, proportionality of the European Union data passenger name record directive. And it's funny because this European directive, in fact, was the ultimate phase of a transatlantic saga who started in 2003, and we don't see yet if it will finish soon. But anyway, the floor is yours. It's a presentation by PowerPoint, so we will follow you.
Yeah, I just don't have the...
Eccolo.
Thank you.
Auto distraction button.
Thank you very much. Thank you, Emilio, for the organization of this panel. Before that I begin, I just will to excuse me for my English. I do a lot of mistakes, but it's why I prepare a PowerPoint, and it's the PNR subject is very technical, so it's very difficult to speak about it in English, but it will be okay. It's interesting to speak about the Passenger Name Record Directive because it's in this domain the first time that the European Court of Justice took a decision about the use of algorithms by the law enforcement authorities. But what's the PNR Directive in very, very, very summary? The PNR Directive obliges all the airlines company to systematically collect all the passengers' data, like the name, the birth date, the address, how they pay the ticket, before that the passengers take the plane from a flight outside EU. The member states have the possibility to extend the system at the flight inside Europe and also at the another mode of transport, train, bus, boat, and it's what, for example, Belgium did. After that, this data must be transferred to the Passenger Information Unit. It's not an independent authority as a judge of investigation, but it's a competent authority. The PUU will have to apply two different processing operations. The first one is a matching PNR data with the database and the blacklist concerning the prevention, detection, investigation, and prosecution of terrorist offenses and serious crime. The second one is the subject of this panel, consists in the application of an algorithm on the PNR data according to pre-established criteria. As we will see, following the directive, there are a lot of conditions. These criteria must be target, proportionate, and specific. Member states shall ensure that these criteria are set and reviewed at regular interval. And these criteria are not in way based on sensitive data because there is a risk of discrimination. The purpose of the PNR method is to identify people who were not suspect of involved in terrorist offense or serious crimes, but who could commit crime. For this reason, this method has been criticized by the Council of Europe because it does not pursue a legitimate objective. We speak about predictive regulation. The purpose is to target people who have not committed any offense, but maybe they could be, and the computers say that there is a risk that they will commit some wrong thing in the future. Following the Council of Europe, this method does not serve a legitimate purpose in a democratic society, and for this reason, this method is fundamentally incompatible with the European Convention of Human Rights, but also the European Charter of Fundamental Rights. This method has also been criticized by the European Data Protection Supervisor because there is no proof that this method is necessary and proportionate to achieve the determinate purpose. EDPS suggests to intensify efforts on no suspects and to profile millions of travelers. For this reason, the PNR directive has been challenged by the European Court of Justice. In the case Ligue des droits humains, Belgian Constitutional Court submit 10 questions for a preliminary ruling on the conformity of the PNR directive with the Charter. So you can see some question. It was about the fact that the PNR introduced a general system for the collection, transfer, and processing of passenger data, provide for a prior assessment of all the passengers, and also, for example, about the general data retention period of 5 years. The question was, the big question, will the court apply the same decision than for the data retention because there is no link between the person concerned, data, and the objective of the measure? In her decision, the court described the interference as serious because the PNR directive introduced a system of surveillance that is continuous, on-target, and systematic, including the automatic assessment of the personal data of everyone using air transport service. But she also considered that this system does not affect the essential content of the fundamental rights. So it was not the same thing that for the data retention, because here the data are limited to certain aspects of that private life relating to the travel of the people. So it's not the same thing than in the data retention, where the information collects concerning all the life of the people. However, the court considered that the seriousness of the interference depends on the processing, and in particular, the algorithm on which PNR data will be processed. The court underlined also that the use of algorithm necessarily presents some margin of error. As you can see, the document of the Commission shows that automatic system lead to 5 errors out of 6 individual identified. So it's a very, the number of error is very high. But the European Court validated the system, but imposed strict conditions. For example, the purpose are limited to fight against terrorist offense and serious crime, with an objective, even indirect, linked to the airport transport of passengers. The PNR system can only be systematically be applied to the flight outside EU. The general retention of PNR data is limited to 6 months after the collection and not 5 years. And for the algorithm, she precise some criteria of the directive. So the directive, following the directive, the algorithms are to be target, proportionate, specific, and not discriminatory, but the court precise what means targeted, and also she precised that the algorithm have to be include incriminating elements and also exculpatory elements. It's difficult to say, but you can read what the court exactly say. It's also important to underline that in her decision, the court prohibits the use of machine learning algorithm, because in case of match, it's impossible to understand why and how the machine take the decision. As consequence, the people can't exercise the right to an effective judicial remedy, in particular to challenge the non-discriminatory nature of the results. Oh, it's not the good side. It's my old website. It's this one. Voilà. So she prohibited the use of machine learning algorithm. However, in case of match or hit, the decision has always to be reviewed by an individual human. No decision which has an adverse legal effect on a person or significantly affect a person may be taken as a result of sole automatic processing of PNR data. And the PUU should only forward to the competent authority those results which, following an individual examination, give rise to a reasonable suspicion of involvement in terrorist offense or serious crime. We can also underline that the decision of the court is based on Article 7, 8, and 52 of the Charter. This article concerns data protection and privacy, in particular, automate individual decision. Discrimination is only assessed on basis of personal data and sensitive data, but there is no attention paid to the identification and mitigation of BA. If we speak about BA, we think directly about the Intelligence Artificial Act proposal, because this act is to impose the identification and mitigation of BA that might be generated by new algorithms sold on the EU market. So the purpose of this regulation is to give a legal framework for the use of the intelligence artificial, and it's also applicable to the law enforcement authorities. The use of intelligence, the use of EA by the law enforcement authorities is classified as high-risk system and require, therefore, sufficient guarantees. So here you can see that that they say that it's that they underlines the importance of the judicial remedies in case of use of intelligence artificial by law enforcement authorities. For this reason, the proposal imposes the respect of condition in case of use of algorithm. You can read this condition there. It's a lot of condition that the court didn't underline or didn't oblige, because it was not the question of the Belgian courts. But maybe in the future, the European Court of Justice might have taken into account if the AI Act was adopted. So it's, for example, the condition could be applied to the use of algorithm in the PNR case, And so maybe it was the PNR case, Ligue des droits humains, the first one of a long series of episodes. And maybe the next one will be about the specialized question about the use of algorithms by the law enforcement authorities. Thank you.
Thank you to you, Catherine. I think that this ruling, which was published on the 21st of June in 22, is one of the most clear examples of judicial lawmaking, because in fact the interpretation of the court, I don't say is changing the text of the directive, but de facto is limiting under several perspectives the content of the European directive. One of the most interesting aspects that you just raised is the case of the prohibition of machine learning. And we know that machine learning is at the core of the artificial intelligence application, and in a way is taking at the level of the data protection the principle that was already clearly stated in the 80s by the Council of Europe Convention on the automated treatment of personal data. So no one can be criminalized by an automated treatment of his own data. You always need a personal intervention, and this is very important. It remains that by adopting the EU directive on the passenger name record, the European Union was in fact mirroring the American approach to preventive policy. And I only hope that we will not follow the Chinese approach of social scoring or individual security scoring, which is not more science fiction. May I just add another point? I am already behind one other request for preliminary ruling of the Court of Justice in some years ago, challenging the legitimacy of the German law transposing the directive. The judge who raised the case before the Court of Justice in Berlin was contacted by the court after the ruling you presented, and then he considered that this ruling was already enough to decide if the German legislation implementing the EU PNR directive was or not legitimate. And in fact, he considered that it was not. And he took a decision. There was an appeal by the German government, but he lost this appeal. And I recently received a communication by the Bundeskriminalamt that my data that were at the basis of a travel that I did by plane from Brussels to Berlin were no more verified under security aspects. So this was for Germany. The point is, how many other European countries have verified if their own national legislation is complying not only with the directive, but with the interpretation of the directive? There is a very concerning, we'll say, letter by the European Data Protection Board some months ago, which was saying that, in fact, after this ruling, probably most of the national legislation implementing the PNR directive are not complying with the interpretation given by the court. The point is, what is doing the Commission? Who is checking, I don't know, the French legislation implementing the EU directive, the Italian directive? No one knows. So I hope not to be obliged to raise other cases for these countries. Now I propose to give the floor to Anze Erbeznik, who is a very old friend and good colleague when I was in the Civil Liberties Committee, and he can give us his own view on these very interesting issues. Anze, the floor is yours.
Thank you very much, Emilio. Can you hear me? It's on. Yeah, thanks a lot. Thank you. Just first, I have to say that the opinion here expressed is my personal opinion and does not necessarily reflect the opinion of the institution. Sorry, I'm obliged to say this disclaimer. Just to say that the digital age offers on one side and the data that is on our disposal a lot of possibilities. So we have the possibility of fast learning, fast communication, knowledge gathering in a way we never had before. However, on the other side, it also poses a lot of risk. Whatever we do, we leave a digital fingerprint, and whoever has access to this digital fingerprint basically controls humanity. And these are not only member states, these are also private enterprises. We are, Emilio already mentioned the Chinese model. We have the possibility of two models in today's world. Either we can be a technological data protection democracy, or we will develop in a different way that we see in this big state in East Asia promoting a different model. The interesting is it's not a model of Big Brother. It's a much more sophisticated model. I don't mean sophisticated in a good sense, but sophisticated in the sense that it combines Big Brother with Brave New World. So they are combining Orwell with Huxley, the two components together. What about the European Union? The European Union, if you follow the digital area, and I follow specifically digitalization or digital question in the field of criminal law or the judicial sphere in criminal law, it's interesting because it's the second phase of the Greek god Janus. It shows you where there are anomalies in a state, you first detect it in the sphere of criminal law. And as regards the European system, there is a certain schizophreny between the digital strategy of the European Union, the data protection strategy of the European Union on one hand, if you compare it with the EU security strategy. On one hand, the digital strategy and also the data protection strategy, they tend to promote fundamental rights or data protection. On the other side, the security strategy promotes the massive collection of data, the massive use of data, and promotes the use of artificial intelligence, which enables the fostering through such data. Specifically for the area of judicial cooperation, there are three worrying developments. The first worrying development is the question of extraterritoriality. And I think Mrs. Sippel will address, for example, the issue of e-evidence, but extraterritoriality is being applied in a lot of different files connected with criminal law and data protection or the digital sphere and broader, for example, terrorist content online, then the temporary derogation from e-privacy as regards the protection of children, the new proposal on combating sexual abuse online. So this is one of the first developments, the use of extraterritoriality and the use of direct cross-border orders. Then you have the second question is the use of private providers that somehow are becoming agents of the state. They are invited to foster through the data, even to loosen encryption or even to get rid of encryption, and they are becoming a kind of torn entities, half state agents, half private companies. And then there is a third quite worrying development that the sphere of intelligence services and the collection of data, also personal data in the sphere of intelligence services, is more and more mixed or crossovered with the criminal law sphere about the question that information collected by the intelligence services is becoming directly, or there is a tendency that it becomes directly formal evidence in a criminal procedure. And as Mrs. Sippel said, the system can survive one anomaly, perhaps two anomalies, three anomalies. If the anomalies become the rule, then then we could ask the question of the system as such. If the system doesn't use data protection and fundamental rights only as a lip service, but basically it mimics more and more the East Asian state that I don't mention the name again. I'm joking, like in Harry Potter. Sorry, it's a joke. So the question is, what will be the nature of EU law? The EU promotes a third way on data protection, but we have to be careful that this third way is not basically mimicking a model we don't want to mimic, and then always at the end says, but in accordance with fundamental rights, which is a pure, or data protection, which is a pure lip service. I will stop here for the moment, and I will add later on some practical examples on Digital Services Act, the temporary derogation, perhaps some words on e-evidence and so on. So thank you for the moment.
Thank you to you, Anze. Birgit, do you want to add something that has been triggered by the previous interventions?
Maybe I would start with artificial intelligence and the example coming from PNR. And the question is, how is it that in the area of security and police, how are we working? And I will start with the real world. Normally, the work of police must be tailored, and it's based on experience or on indications, information that you get. But this is no longer the case when we talk about the digital area. So, of course, every single person might become a criminal by some circumstances, but this could also happen in the real world then. But being aware that, for example, this famous and emotional case of child sexual abuse, this has taken place in real world, and we don't like it, but it may happen in our neighborhood. Does it mean that police forces, investigators, are looking into every household to ensure it's not happening? Of course, we are not doing that. But talking and changing to the digital world, obviously, some people intend to do rightly this, look into everything. And that shouldn't take place. You need some more indicators, experience. And when we turn this to artificial intelligence, your experience might be totally wrong or might change. So, but if you put some of your experience into the system and say, take this like is a fact and continue to work with this, it will continue some data. Also, when we talk about predictive policing, I remember another visit in Washington. We always believe we have to copy-paste what's coming in this area of security from the United States. And they had some systems in some of the countries, for example, in Boston, but Boston police gave up the system of predictive policing because they said whatever the data are you give in, very soon the work of criminals will change. So the starting point of the system already might no longer be true next day. Also the question what kind of data you gave in. So the data you are using might already be biased. And when we talk about machine learning, what's the basis for machines to look into, to develop their minds? And it's very problematic because I have the impression that some legislators believe we create a system of artificial intelligence once, and then that's it. Finish, forget about the next 10 years, we have a system. But that's not true. You have to work on the system every day because society is changing, behavior of criminals is changing. So if you don't want to continue biased data, that's a problem. In the United States, we had the problem that many pictures of criminals who already have been convicted were imprisoned. And we know the system in the United States. Many of the criminals, of the convicted person, were colored people. So the system learned most of the criminals might be colored people. So that bias is continued. Another point that is important, so I only can underline the need that if you use an artificial system, the most work needs to be done in preparing the system. and continuing working on it. And nevertheless, whether it's in the area of security or simply in a banking sector, who is deciding who gets a loan, yes or no? People working with the system always need to have the possibility to oversight, to correct, to change, so to ensure that the interests of the people and the rights of the people are not negatively affected. So that's a precondition for everything. And I may say another sentence on PNR, CSAM, the interim system was mentioned. We are turning to a situation where seriously everybody is under surveillance. We start with PNR, which to some extent the European directive is even worse than the agreement with the United States, because we were talking about international flights, opening the door for internal flights, and even having debates about controlling everybody using a train, a ship. Some member states are controlling the signs of cars to see if someone is traveling with a sign that was stolen. We have the entry-exit system now under control, where we control everybody crossing a border. And we have the CSAM, where if we look into the proposal of the Commission, in the end, it can happen that really all kinds of communications is surveyed at any time. And another problem here is the question of interoperability. So the tailored work of investigators is the one question. But if we want to avoid that our data are used for nearly everything by everyone, we need clearly defined access rules. And we started interoperability by saying, yes, but the access rules will not be changed. Those persons who have access to specific data should have that access regarding to different databases only to those data. But now it seems that we are increasing access data. So is it police? Is it border guards? Is it someone else? They all might, to some extent, have access to data. And we had this problem also with the screening part of the Asylum Pact, where the Commission simply says, oh, the authorities can have access to all those databases, Schengen, visa, entry-exit system. But who are the authorities? It's not defined. It's not defined. There is no idea given who is it. So in the end, it might happen that anybody might have access to all those sensitive data. And that is something that we really have to keep in mind. The fact that you mentioned, it's good that the courts are working and correcting the work. But I would like to see what I think it was Commission President Juncker was calling better lawmaking. I think we cannot decide laws and say, oh, yes, it might be critical, but then someone can go to court and then let's see, maybe the court will reverse the situation. No, I want us as legislators, the Council, the Parliament, but also the Commission who is doing the proposals to do its very best to avoid to the biggest extent possible that a legislation needs to be challenged in front of a court and is challenged in front of a court. That's not better lawmaking. And therefore, with all the questions of using digital area, using artificial intelligence, I think it's first of all, on the European level, having in mind that the Commission is the only one proposing legislation. It's their absolute duty to do their very best to ensure that the legislation is fine, is good for the purpose, and is at the same time protecting fundamental rights. And it's really concerning me that again and again and again, the Commission is not doing impact assessments. And especially when we talk about the digital area, when we talk about using artificial intelligence services, all these things will have effect to personal data, to persons. So it's even more important than ever to look into possible effects of a legislation, and this is not happening. So I hope that Parliament also in future will play a role as a little bit controlling things, but this should not happen, and we really should be careful. But I'm also happy about what Anze just said, that of course there are big chances in using digital areas, digital data. No doubt about that. And if people say, but we can't work on data protection, so it's too hard. We need to think about economy, we need to think about security. But in all these systems, if you think about data protection from the very beginning, we can create the systems to have security and protecting fundamental rights. The only thing is we have to think about it from the very beginning.
Thank you very much, Birgit. Privacy by design remind me something. But in fact, you know, sometimes the music change when the players change. And we know that since 2001, in fact, after September 11, one of the dreams of the Commission was to become the Homeland Security Department in the European Union. And this has changed more or less everything, notably with the splitting of the portfolio when the Lisbon Treaty entering into force. So we had the paradox that at the moment when the Charter became binding and the treaty entered into force, there was a sort of Dr. Jekyll and Mr. Hyde with the same hat, and was not easy to understand how to deal with. Anyway, Merve, you want to intervene, please?
Not so much to intervene or contradict, but I want to add a few things, both on predictive policing and the social scoring piece. So on predictive policing, the way it works is, and it is what it says on the can, right, is you're trying to predict someone who's going to commit a crime or where a crime is going to be committed. So you're not reacting post a crime and trying to do law enforcement and investigate a case that had happened, but you're trying to predict something before it happens. And the way it works right now, and the way it will always work, because it's a pseudoscience, my personal opinion, pseudoscientific approach, is it undermines the presumption of innocence first, and it creates spurious relationships. So you're making decisions, you're making predictions based on spurious relationships, correlations that you find in the data set, not necessarily causal relationship. If something happens, if someone does this, there is going to be a crime. There is no such direct causal relationship. You're just finding correlations, and sometimes, like I said, erroneous and spurious ones, and you're acting on it and considering someone is going to commit a crime, hence they're risky, hence they should be arrested. One case that we had in the US was this case of predictive policing used in, I want to say Chicago or Los Angeles, don't quote me on the location. But the police department was using this predictive policing software, proprietary software. However, the software was not able to distinguish between if someone was on the heat map, if the person was going to be the perpetrator of the crime, like the person committing the crime, or if the person was going to be the victim. There's a huge difference, right, between the two of, like, you want to be, if you're going to predict something, you want to be more clear about what you're going to predict and who you're going to arrest. So they kept knocking on the door of this person, black guy in a relatively low-income neighborhood, as always usually is the case. And they said, you keep coming up on the heat map. We don't know if you're going to be a perpetrator or a crime. We don't want to check on you. And while we're here, we want to check inside your house without a warrant. So they went into the house. A while later, a few weeks later, popped again. So they came back to the house, like, your name comes up again. We just want to check on you one more time. What that did was people, actual criminals in the neighborhood, thought that the guy was cooperating with the police, that he was snitching on what was happening in the neighborhood. So they came and shot the guy, and he became the victim, right? So the predictive policing software became this self-fulfilling prophecy, and then the police can say, yes, the software was right. It did predict that the crime was going to happen. He was at the end the victim, but the guy was shot. He lost his job. He can't live in his neighborhood anymore. So police is now hands off. There is no regulation. neither in US, I would think, nor in Europe, against that kind of thing. So that was one of the reasons that we were also fighting against predictive policing. I want to say one more thing on the social scoring piece. We have a tendency both in the EU and US to show you don't want to be China. China is doing bad things, not necessarily reflecting on like holding the mirror to ourselves, our practices, our governmental practices. At the center at CIDP for 3 years, we've been conducting this extensive research called AI and Democratic Values Index report. It is a comparative report on what the governments commit to, trustworthy AI, human rights, human centricity, etc., versus what they actually do in practice. One might say, okay, we're committed to OECD AI principles, we're committed to Universal Declaration of Human Rights, and turn around and discriminate against migrants and asylum seekers and refugees, conduct predictive policing, etc. So we've been trying to map this conflict between commitments and practice on the ground for 75 countries. And a lot of the stuff that we found, not only in the US, as well as in European countries, there's a huge gap between commitments and practices. So we might say that these are the developed countries where fundamental rights are at the forefront. However, there are a lot of practices, whether it's, like I said, predictive policing, whether it's flagging low-income families for risk or fraud, etc., whether it is treating people looking for asylum or refugee protections with a separate human rights approach. So we have one approach for citizens inside the country, a separate approach which is lacking a lot of the protections for people asking for this, for determinations. So I want to say, like when we say we don't want to be China, we want to ban social scoring. I personally don't understand what EU is banning under ban social scoring, because the only context that I can get from it is we shouldn't be using data collected in one context to make judgments, or make scoring for another context, right? So that's the essence of that ban. How about when we use social media posts to make determinations for people's employment? How about when people are applying for credit and we're using social media and other stuff? How about we get all this data created and collected in other contexts used for immigration purposes? So what is it that we're banning with social scoring in the EU AI Act? And if that becomes, if eventually when that becomes law, how is it going to be actually implemented as a ban is, again, one of my big questions.
Thank you, Merve. Very worrying, I will say. Catherine, you want to add something?
No, not for this moment. Thank you.
Okay, but the moment will soon end up because we are in the end. So, Anze, you want to add something?
Yeah, I would just like to give, because I promised you some examples. First, I would like to address what was mentioned before, the problem of impact assessment on data protection and fundamental rights and privacy in general when the Commission is proposing instruments. Let's take, for example, the e-evidence proposal where the Parliament was trying for a significant amount of time somehow to address legal issues and divergences that were not addressed in the original Commission proposal. When the Parliament organized a hearing on e-evidence in 2018, there was also an invitation to a vice president. He's now vice president of the European Court of Human Rights. And what did he state about the original Commission proposal? He said the interferences with Article 8, this is right to privacy, on the European Convention on Human Rights, are without any involvement of the authorities of the enforcing state. I wonder if this is in line with the European Convention on Human Rights. So this is quite a strong statement by a vice president of the European Court of Human Rights about the original Commission proposal. Then let's take another example, the one on the protection of children and getting rid of encryption. it doesn't happen so often that one institution goes in direct combat, especially the legal services of one institution would directly combat the legal service of another. This is a rare happening. So if the Council Legal Service made such a critical opinion about the Commission proposal on the online protection of children, basically they said that the proposal is disproportionate, does not respect privacy or data protection. This should really alert the legislators utmost. Let's take another example, terrorist content online. On terrorist content online, perhaps it's not so much connected with data protection per se, but there we had an opinion of three special representatives of the United Nations, one on freedom of expression, one on privacy, and one on the fundamental rights and terrorism. And they said that the Commission proposal is basically not even adhering to UN standards as regards the definition of illegal terrorist content and as regards the authorities that should trigger also cross-border indications. The UN, usually the UN triggers issues about third developing countries. So this is again my personal opinion, it's quite shameful if the UN has to take up an issue and criticize the European Union, who is in principle or should be one of the caretakers of data protection and fundamental rights. Just to finish, and this is my last remark, for example, for e-evidence, before I mentioned one of the main problems on data protection today in this new instrument is this extraterritoriality and direct cross-border orders. The Parliament invested a lot of times as regards the introduction of certain notification possibilities, in the sense that the authorities where the data is being taken from has a certain saying or possibility to stop such taking or transfer of data. And my last remark, what was said before, there is also a misconception when we speak about security, fundamental rights, privacy, and so on. In a democracy, you cannot have full security. You can have full security, but then the system will not be anymore a democracy based on data protection and fundamental rights. Thank you.
A very challenging statement. In fact, if I'm not wrong, the preamble of the Charter of Fundamental Rights says that all the EU policies should be framed and have the individual at the center of the policy, not the duty of the administrations. In fact, behind the request for security, sometimes you are really limiting the freedom of the person, of the people, and even the feeling of being part of a community. So, unfortunately, we are approaching the end of the time for our panel, so it's not possible to give the floor to the audience. Let's hope that for the future, in this kind of predictive policy, we will not invent other dreams of techniques like astrological provision that will make impossible for a person to defend himself before the judge or the law enforcement authority. Thanks for your attention, and thanks to the participants of the panel for these very interesting and lively debates.